I have three parts to the program, and I'm going to be very, very brief. I'll introduce Steve Kukos from Chu, Ring, and Hazel, who is our update expert. Bill Eaton from Merrill Lynch is going to tell us how we can update our portfolios to ensure that we can all retire on time. And Charlie Murphy, the chairman of the House Ways and Means Committee, is here. He's outside taping an interview right now, and he'll be joining us momentarily as hopefully the number 2 speaker after Steve. And as you all know, the drill is we have our 3 20-minute presentations, and then we'll throw it up to robust questions from all of you. So, Steve, you want to kick it off?
So I trust everyone has the handy-dandy update template in front of you, and if I go through all of that in the level of detail it's in, I probably would be well over my time allotment. So I'm going to probably take some liberties in terms of abbreviation or glossing over some of these things, but in keeping with the tradition, what I've tried to do is have a chronology of the developments over the last couple of weeks, broken out through the different sections, the administration, the different agencies, etc. As some of the same themes come up in with respect to different agencies or parts of this outline, so we'll try to tie some of that together as well. So starting with what's the administration been up to over the last couple of weeks? Well, going back the week before last, President Obama met with the representatives of 15 of the largest credit card issuers and networks to express his views regarding necessary reforms for consumer credit card practices. And this is, in addition to the process that's winding its way through Congress. The House actually passed a bill on April 30th. The Fed, adopted Reg Z changes last year that go into effect July of 2010. There's a lot of activity going on, whether it's administration, legislative, regulatory on consumer credit card practices. The question is, does it all come out in the same place, or is it any different what Congress or the President is advocating versus what the Fed proposes to do? Most of the opinion on this tends to be that legislatively they'll get you to the same place the Fed is going to have you in a year. So why do that? But the notion being that regulations can be undone. They want to put some of these changes directly into the law. And I think from the President's perspective, he wanted to add his weight to that legislative initiative. So the President met with those representatives. The administration also recently announced that it was trying to build on its loan modification efforts by, in effect, integrating the existing Hope for Homeowners program into the more recent administration initiative of Making Home Affordable program. What he's trying to do there is there's certainly legislative changes that need to be made from the loan servicer's perspective in terms of potential legal liabilities. Those are in Congress currently, but there also are impediments to loan modifications built into the system right now. And this initiative in particular is trying to provide less of a haircut to first mortgage lenders and specifically addressing second lien holders, which has proved to be a major impediment to trying to do loan modifications, where if you're modifying the first mortgage but not the second, how's that supposed to work? The administration also announced recently that it brokered a deal to put Chrysler into bankruptcy. Major headlines, with the secured lenders proposed to receive $2 billion in cash for their nearly $7 billion of senior unsecured debt. The United Auto Workers would be 55% owners of the reorganized company, with the U.S. and Canadian governments between them having about 10%, and the car maker Fiat having up to 35%. It's in bankruptcy. It remains to be seen how the bankruptcy court deals with the plan, whether it accepts it. Certainly, there's a fight there to be had with the senior secured lenders, those calling themselves the non-TARP lenders, i.e., not the big banks, but the hedge funds and the and other investment funds and institutional investors that have basically bought the debt on the market. Some arguing that the proposal, in effect, turns established bankruptcy principles on its head in terms of how senior lenders are being treated with respect to other more junior claims. Finally, just this past on Monday, the administration announced proposals to limit the use of offshore tax avoidance planning or schemes by U.S. multinational corporations and wealthy individuals. These are pretty, complex areas of tax law, and I won't delve into them. But on the day of announcement, we had sort of pushback that business, this is sort of a frontal assault on some pretty well established business corporate tax planning in the multinational realm. So expect a fierce fight on that. Over to Treasury. April 24th, Treasury officials disclosed the results of the stress tests in private meetings with the senior management of the top 19 U.S. bank holding companies. These are the companies each with $100 billion or more in assets. Initially, the intention was that the companies would have until the following Tuesday to, in effect, challenge the results, to push back on what the regulatory agencies had determined. And there would be public disclosure of the results set for, initially it was set for May 4th, for Monday. Now that obviously didn't happen. The so-called challenge period has dragged on. We have almost every day, or at least every other day, news articles on the leaks as to where the stress tests, how they're coming out, where they're going. We now have an intended and public disclosure announcement date of how the tests came out of tomorrow after the close of the markets. Now, the stress tests, as I think you're all aware, are scenarios in which, sort of looking at the 19 largest institutions throughout their different operating areas and asset and liability classes, looking at them under sort of a consensus scenario of where the economy is going this year and next, and then under a more sort of heightened, severe worst case, although I don't know if you can ever, in theory, say this is the worst of the worst cases, but certainly a much more adverse case, and how those institutions would fare, looking at them sort of across the group of 19 as well as drilling down individually into each one and trying to determine, what is their state of capital adequacy. Under interagency, basically, I've tried to give you a little bit of a flavor of how it's been going almost on a daily basis in terms of the stress test and the attention being given to that in the press and the commentary. The agencies, on the day that the Treasury was discussing its results with the banks, released a white paper in which it attempted to try to explain the methodology behind the stress tests, and we've had just ongoing commentary since then. The Journal, the Wall Street Journal, reported on the 27th that both Citigroup and Bank of America have been told that they're going to need capital. How much capital? At one point it was $10 billion, but we don't really know. On just 3 days after that, the American Banker reported that, it looks like at least 2/3 or so of the group of 19 have, quote, passed the tests. Of those 6 or 7, they're going to need capital. Maybe only a couple are going to have to try to raise it sort of externally versus just converting the preferred shares that Treasury already holds to satisfy their capital, to convert that into common equity. Then on Monday, the Journal was back out there saying, well, no, actually the number is more like about 10 that are going to need to have capital. But in an interesting turn of phrase, the paper reported that The exact number of banks that will be determined to be in need of capital, quote, remains under discussion. So, the analysis continues to be back and forth between the regulators and the banks, although tomorrow, presumably after the markets close, we'll find out for sure. The market, nonetheless, the stock market seemed to be encouraged by some of the things that they were hearing, perhaps that it wasn't the meltdown scenario, and bank stocks rose significantly, at least some of the large ones rose significantly on Monday, although they were back down on Tuesday through profit-taking and whatnot. Over at the Fed announced on Friday that it was expanding the scope of the eligible collateral under its TALF program, the so-called Term Asset-Backed Securities Loan Facility. It now will include securities that are backed by commercial mortgage-backed securities, not residential, but commercial mortgage-backed securities, in addition to securities backed by auto, credit card, student, and small business loans. And remember, TALF is the program in which institutional investors can be financed through a Fed facility to purchase these securities. It's also extended the maturities of the loans from 3 to 5 years. All of this is an attempt to try to build more attraction to the program, which, as we talked, I think Neil mentioned the last time we were together, really hasn't been embraced by the institutional investor community in the way that one might hope to facilitate the liquidity that it's intending to inject into the system. The FDIC had some interesting activities going on the last couple of weeks. Not this past Friday, but the Friday before that, we had 4 more banks. That seems to be about par for the course right now. $2.3 billion in assets total on those failures. The projected costs of the resolutions for those 4, the FDIC was pegging at $700 million. They were, ranged from $1.5 billion, First Bank of Beverly Hills in California, to American Southern Bank in Georgia, $112 million. Those seem to be pretty. Those jurisdictions, those areas, we can count on them to keep giving us a few more of those banks. It seems like Georgia, no offense intended, has been a ready supplier in the failed bank chain. So the FDIC also made public on the 24th its enforcement orders that had been issued during the month of March. And as we might expect, a lot of cease and desist, 23 cease and desist orders were issued, as well as 2 removal and prohibition orders and 13 civil money penalties, which, you don't see civil money penalties all the time. But in the environment we're in, and again, these are cases that were historically from not last month. The orders were last month, but these are cases where internal issues, fraud issues, in terms of civil money penalties. The cease and desist orders would be in response to adverse examination findings. What happens when you go beyond the mere, the mere mild criticism, the informal, we'd like you to do this, we'd like you to do that to rectify your situation. When the FDIC sees, major issues in the banks that they regulate, and the CAMEL ratings typically, if 1 to 5, 1 being best, 5 is worse. When you hit that rating of 4, you're going to get a cease and desist order, and that puts legally binding commitments onto the prescriptive remedies that the FDIC expects from the banks, or puts the management as well as the board of directors under the spotlight, taking responsibility for those remedial actions that are being prescribed. So no surprise really that we see significant uptick in recent cease and desist orders. None of those, I might add, within the New England area that I saw on the public listings. Although that I can tell you, and I can tell you with direct personal knowledge, that's going to change in the coming months. We'll have a few on that list as well. In a speech in New York, FDIC Chairman Sheila Bair, continues publicly to argue her case on behalf of the agency as being the sole agency that should be authorized with resolution powers for so-called systemically important non-bank institutions. And I'm just going to jump to a miscellaneous item I had in the back of this. It's with respect to the battle that's going on right now with respect to the Washington Mutual situation. WAMU, of course, failed, was resolved. FDIC is the receiver. Bank assets transferred to J.P. Morgan. There's $4 billion of deposits that were with the bank at the time it was taken over or transferred to J.P. Morgan. The bankruptcy trustee is arguing on behalf of holding company creditors that $4 billion belongs to the holding company. Morgan argues that it belongs to them because they were properly within the bank. The FDIC is arguing that it actually, at least in part, belongs to them. That type of sort of multi-pronged, situation within a resolution of a large bank with a large holding company that has independent, operations and creditors is not unusual in that size of resolution. You saw it in the last wave, going way back to Bank of New England and some of the others, where you had major battles between the holding company creditors and the FDIC and its receivership capacity. I think that's one of the complex scenarios that might be potentially short-circuited or bypassed if FDIC were in charge of the entire resolution. The holding company at that point wouldn't be in a separate federal bankruptcy proceeding. It would be all subject to FDIC resolution. So those are one of the things that the FDIC chairman looks at and says life would be a lot simpler if I was in charge of it all. The FDIC also issued a couple of significant financial institution letters, which are guidance to the constituency, to the constituent regulated state banks. The first basically stated that loans to refinance performing residential mortgages shouldn't be adversely classified just because when they refinance, the loan-to-value ratio may be much higher than typically would be viewed as appropriate under conventional underwriting standards. What the FDIC is trying to get at here is a note to its examiners, as well as the banks, that we've got declining property values. By definition, owner's equity is low. Don't let that in itself keep you from refinancing into lower rate mortgages where you've got a credit-worthy borrower that will otherwise be benefit from that refinancing. The other financial institution letter was guidance with respect to taking into account that the credit rating agencies didn't necessarily do the best job possible on rating what's referred to as structured credit products. That's mortgage-backed securities, collateralized debt obligations, asset-backed securities. All of these securities that are out there that have been subject to the illiquidity and the impairment of the last 12 months or so were highly rated investment grade when they went out the door. The FDIC's latest guidance basically says you've got to undertake your own independent, individual, informed investment analysis. You have to understand how the different tranches work. You have to really understand whether or not this is a suitable investment for you, the bank, and not simply look at it and say AAA rated, we're off and running. The final FDIC entry I had here was another bank failure, and I'm sorry it did come out of Georgia as well, but it was particularly noteworthy, and this was this past Friday. It was Silverton Bank, N.A., a national bank, that was actually a banker's bank. It was actually the nation's largest banker's bank, meaning it provided correspondent banking services to bank clients and was owned by bank shareholders. Silverton didn't fail because of its correspondent banking services. It failed because it was heavily involved, in addition to its normal correspondent services, it was heavily involved in commercial real estate development, both directly as well as taking participations in the various commercial real estate loans that its correspondent customers were engaging in. It was a national bank. It had broad interstate branching capabilities. It had customers in 44 different states. As soon as the failure was announced, the OCC was being subjected to criticism of how could you let this happen? They converted to a national charter just to pursue this business plan of being able to be, across, on a national basis. And lo and behold, 2 years after they convert their charter, they fail. So, there's always someone who, sees blame to be, levied on these situations. From the OCC's perspective, their response was, we reviewed the business plan, the lending, the commercial real estate lending aspect to it, on top of the correspondent services, and it seemed to be a sound business plan at the time. Over at the NCUA, the National Credit Union Administration, lest we forget about credit unions, we had a significant failure in Florida 2 Fridays back, $1.6 billion in assets. But maybe a more interesting item that I thought was interesting anyway was that on the 24th, the NCUA announced that in an effort to stabilize corporate credit unions, and corporate credit unions are the credit union parallel to bankers' banks, providing correspondent services to credit union customers, the so-called natural person credit unions. The NCUA announced that it will permit corporate credit unions to use the capital levels reported in their November 30, 2008 call reports for regulatory capital compliance purposes. In other words, without putting restrictions on the activities they engage in because their capital has fallen to levels deemed to be below where it should be. Now, many of the corporate credit unions have recorded substantial impairment charges on these so-called private label mortgage-backed securities that are in their portfolios. They're heavily invested in those. Those are mortgage-backed securities issued by non-government agencies, non-Fannie Mae, Freddie Mac. And in fact, those charges took down the 2 largest corporate credit unions in the U.S. A couple months back. They were placed into conservatorship with the NCUA, U.S. Central Federal Credit Union, Western Corporate Federal Credit Union. The point here being that capital levels have been severely adversely affected through the write-downs required on these impaired securities assets. They already have the 2 largest ones in conservatorship, and they've now issued this announcement to say, you know what, we're going to look at your capital as if it was November, because the accounting requirements that tell you to write this all down shouldn't in and of themselves have severe regulatory implications. I think that's a pretty significant development coming out of the NCUA. It's a concept that's been discussed a lot by the commentators on banking, but hadn't been nobody's adopted that. But the NCUA, which often sometimes is out on its own, has done just that. I'm going to skip over a few things just because my time is going rapidly. And on the SEC, I think maybe what's a couple of interesting things there. I mean, we had sort of the latest headline Ponzi scheme with Danny Pang, who's allegedly defrauded hundreds of millions, defrauded investors of hundreds of millions. He's had an asset freeze in order to repatriate assets that were also sent overseas, and finally he was arrested by the FBI on criminal fraud charges. The SEC also, while it hasn't formally announced, the expectation is that they will eliminate the broker voting, the permissibility of broker voting in director elections. What this is in uncontested elections where shares are held in street name and there hasn't been a direction to the brokers how to vote the shares, brokers will typically vote those shares on behalf of the underlying beneficial owners. By eliminating that ability to vote the shares where they haven't otherwise been directed how to vote, the sense is that'll give much greater influence and leverage to institutional and other activist shareholders, because those shares are typically voted along management lines. Finally, the SEC Chairman, Mary Shapiro, announced that the agency is reviewing the adequacy of asset allocation disclosure in so-called target date funds. These are funds that you invest in for retirement planning or college tuition planning. They're supposed to, adjust the assets automatically over time as you get closer to your end date, and you're going to need the funds. Presumably, they're in more conservative investment options. The SEC is looking at those, given the surprisingly poor performance of some of those funds in the recent market downturn we've had over the last year or so. Some of those being down as much as 25% at a point in time where you would have thought they'd be in investment options that would be preserving capital. So the SEC's announced that it's going to be looking into those situations. Finally, in Congress, I mentioned, maybe one major headline that came, of course, was Arlen Specter's switch of parties from Republican to Democrat. I refer to a veto-proof majority in the Senate. Of course, what I'm really referring to there is a filibuster-proof majority. One doesn't expect that that the democratically controlled Congress is going to need to override vetoes too often from the president. But what this is getting at is the notion that the Democrats now with Specter have 59 seats in the Senate. If Al Franken wins, as he's expected to in Minnesota, that'll give them 60. That's enough to override any filibuster strategy that the minority might try to engage in to impede or prevent legislative initiatives that the president and the Senate leadership and the Democratic side support. This certainly is seen as sort of a game changer in terms of the ability to push not only financial reform but the president's various initiatives across the board. On the 29th of April, the House Financial Services Committee, in fact, passed a mortgage reform bill. It had significant Republican support. This was the bill that Congressman Frank has been championing. The bill requires federal regulators to issue regulations that ensure borrowers will have the ability to repay their mortgage, and when refinancing, that the loan provides a net tangible benefit. So it's putting responsibility on the lender to determine the borrower's ability and benefit from the transaction. Now, there's a safe harbor in there for basically conventional fixed and adjustable rate mortgages. Now, part of that bill also is intended to try to keep some of the risk of the mortgage lending on the bank's books, as that's been something that people have talked about, is the ability to sort of originate the subprimes and then spin them out in securitizations. The banks had no residual risk. The bill will maintain 5% of the residual risk with the bank, although that won't apply to loans that are in the safe harbor. So in other words, it's attempting to try to get at non-conventional, presumably higher risk, including subprime loans, and basically saying if you're saying that it's sort of appropriate business strategy to be doing that, well, then you should be holding on to some of the risk as well. You shouldn't just be able to originate and spin it off completely. Yeah. I'm going to sort of leave that there, and maybe the only other one item that I'm going to mention is the current Supreme Court case where oral arguments were heard in Cuomo versus Clearinghouse Association. This is a very, very significant preemption case, which the OCC has been sort of undefeated on over the years. But that's a case where the question is, does the OCC, by virtue of its exclusive examination powers over national banks, have the power to enforce state consumer protection and fair lending laws, which are not preempted? So the laws are in effect, they're not preempted, but who can enforce them? The OCC says they can exclusively, as the sole examining authority of the banks. State attorney generals differ, and that's a major case to look at.
Great.
So I'll leave it there. Thanks.
Okay.